A very warm welcome to my YouTube channel. Let's know law. Myself, Maninderjeet Kaur. Today I'm here with a very important judgment of the CRPC. Its name is B.S.JOSHI and other versus State of Haryana and another. AIR 2003 SC 1386. In the petitioner side, there were B.S.JOSHI and others, and in the respondent side, there were State of Haryana and another. The date of the judgment was of 30th of March 2003, and the bench which delivered this judgment comprises of Justice Y.K. Sabharwal and Justice H.K. Sema. So, in this judgment, various laws were discussed or introduced related to the section 482 of CRPC, which deals with inherent powers of High Court, Article 226 of the Constitution, which confers power to the High Courts to issue orders, directions and writs, Article 227 of the Constitution, which deals with power of superintendence over all courts by the High Court. Section 498 of A of Indian Penal Code deals with husband or relative of husband of a woman subjecting her to cruelty. Section 406 of Indian Penal Code deals with punishment for criminal breach of trust. Section 320 of the CRPC deals with the concept of compounding offences. Here, compounding offences refers to a compromise that is arrived at by both the parties pertaining to a case. And the last is section 397 of CRPC, which deals with calling for records to exercise powers of revision. Next, I'm going to discuss the concept of this case, that is the overview of this case or the case related to which things or what are the basic concept of this case. Okay, the question that falls for determination in the instant case is about the scope and ambit of the inherent powers of the High Courts under section 482 CRPC, read with Article 226 and 227 of the Constitution of India to quash criminal proceedings. Quashing means to stop something that you do not want to happen. The scope and ambit of power under section 482 has been examined by this court in chain of earlier decisions. But in the present case, that is required to be considered in relation to matrimonial disputes specifically. So, the matrimonial disputes of the kind in the present case have been on considerable increase in recent times, resulting in filing of complaints by the wife under sections 498A and 406 of the IPC, not only against the husband but his other family members also. When such matters are resolved either by wife or husband on agreeing to rejoin the matrimonial home or mutual separation of husband and wife, and also mutual settlement of other pending disputes, as a result where both of sides approach the High Court and jointly pray for quashing of the criminal proceedings or the first information report or a complaint filed by the wife under sections 498A and 406 of the IPC, can the prayer be declined on the ground that since offences are non-compoundable under section 320 of the code, and therefore it is not permissible for the court to quash the criminal proceedings or FIR or complaint. So the facts of the case are as the facts here are not in dispute particularly as such in this judgment. As an overview, the facts were that there was a dispute in between appellant, that is husband, and respondent, that is his wife. After 1 year of marriage, they had decided to live separately. An FIR was registered under section 498A and 406 of IPC at police station, Central Faridabad, at the instance of the wife. Later on, she has filed an affidavit that the FIR was registered at her instance due to temperamental differences and implied imputations. According to that affidavit, her disputes with appellants have been finally settled, and she and the appellant, that is her husband, have agreed for mutual divorce. The affidavit further states that on filing of the petition for the mutual divorce, statements on first motion were recorded. Also that in second motion filed by the parties to the marriage, their statements were recorded by the Court of Additional District Judge, Delhi. Counsel for respondent, that is wife, supporting the appeal, also praised for quashing of the FIR. There was, however, serious opposition on behalf of the state. The High Court had, by the impugned judgment, dismissed the petition filed by the appellants seeking quashing of the FIR. For in view of the High Court, the offences under sections 498A and 406 are non-compoundable, and the High Court held that the inherent powers under section 482 of the Code cannot be invoked to bypass the mandatory provisions of section 320 of the Code that deals with the compounding of offences, that is, compromise between the parties. For its view, the High Court has referred to and relied upon the decisions that are State of Haryana and other versus Bhajanlal and others, Madhulimai versus State of Maharashtra, and Surendra Nath Mohanty and another versus State of Orissa. Later on, a special leave petition was filed in the Supreme Court. So, the facts in issue in Supreme Court were that whether the High Court in exercise of inherent powers can quash criminal proceedings or FIR or complaint, and does section 320 of the Code limit or affect the powers under section 482 of the Code. So, in the judgment given by the Supreme Court, the Supreme Court's view in relation to reference given by the High Court of the case named State of Haryana and other versus Bhajanlal and others. Supreme Court of view that after reproducing the 7 categories of cases as given in paragraph 102 of Bhajanlal's case, the High Court has held that the parameters, principles and guidelines are for quashing of complaints, first information report and criminal proceedings have been settled in terms thereof, and has concluded therefrom that the instant case does not fall any of the said categories. It is quite clear that the High Court has lost sight of the earlier part of paragraph 102, which made it abundantly clear that the said categories of cases were being given by the way of illustrations. Neither the category of cases given were exhaustive, nor it could be so. The Supreme Court had further given reference of the case named Pepsi Food Limited and another versus Special Judicial Magistrate and other 1998. While referring Pepsi Food Limited and another versus Special Judicial Magistrate and another case, Supreme Court with reference to Bhajanlal's case observed that the guidelines laid therein as to where the court will exercise jurisdiction under section 482 of the Code could not be inflexible or laying rigid formulae to be followed by the courts. It held that exercise of such powers would depend upon the facts and circumstances of each case, but also with the sole purpose to prevent abuse of the process of any court or otherwise to secure the ends of justice. It further said that it is well settled rule that these powers have no limits, that is, inherent powers of the High Court have no limits. Of course, where there is more power, it becomes necessary to exercise utmost care and caution while invoking such powers. Supreme Court held that the decision in Madhulamai's case has been misread and misapplied by the High Court. According to the Supreme Court, the question considered in that case was when there was a bar on the power of reason in relation to any interlocutory order passed in an appeal, inquiry, trial, or other proceedings, what would be its effect on exercise of power under section 482 of the Code. Subsection 2 of section 397 of CRPC providing that the power of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceedings was noticed. So, it was held that on a plain reading of section 482, it would follow that nothing in the code which would include subsection 2 of section 397 also shall be deemed to limit or affect the inherent powers of the High Court. Supreme Court further held that it is thus clear that Madhulimai's case does not lay down any general proposition limiting power of quashing the criminal proceedings or FIR or complaint as vested in section 482 of the Code or extraordinary powers under Article 226 of the Constitution of the India. Supreme Court had view in relation to reference given by High Court of the case named Surendranath Mohanty and another versus State of Orissa, that is 1999 case. The Supreme Court has held that the High Court has also relied upon the decision in case of Surendranath Mohanty's case for the proposition that offence declared to be non-compoundable cannot be compounded at all even with the permission of the court. That is of course so. Supreme Court said that the offences which can be compounded are mentioned in section 320. Those offences which are not mentioned herein cannot be permitted to be compounded. In Mohanty's case, the appellants were convicted by the trial court for offence under section 307. The High Court altered the conviction of the appellants and convicted them for offences under section 326 of IPC and imposed sentence of 6 months. The trial court had sentenced the appellant for a period of 5 years with rigorous imprisonment. The application for compounding was, however, dismissed by the High Court. This court, holding that the offence for which the appellants had been convicted was non-compoundable and therefore it could not be permitted to be compounded, but considering that the parties had settled their dispute outside the court, the sentence was reduced to the period already undergone. It is, however, to be borne in mind that in the present case, the appellants had not sought compounding of the offences. They had approached the court seeking quashing of FIR under the circumstances above stated. So, the Supreme Court has given reference of other cases in the judgment, and these cases are State of Karnataka versus L. Muniswamy and others of 1977, Madhavrao Jivaji Rao Sindhya and other versus Sambhaji Rao Chandoriji Rao and others 1988, and G.V. Rao versus L.H.V. Prasad and others. The Supreme Court's reference of case named State of Karnataka versus L. Muniswamy and others. As we all know, the Supreme Court has given reference of this case. In this case, considering the scope of inherent powers of quashing under section 482, Supreme Court held that in the exercise of this wholesome power, the High Court is entitled to quash proceeding if it comes to the conclusion that ends of justice so require. Further, the Supreme Court also referred a case named Madhavrao Jivaji Rao case. In this case, the Supreme Court held that While exercising inherent powers of quashing under Section 482, it is for the High Court to take into consideration any special features which appear in a particular case, to consider whether it is expedient and in the interest of justice to permit a prosecution to continue, where, in the opinion of the court, the chances of an ultimate conviction is bleak, and therefore no useful purpose is likely to be served by allowing a criminal prosecution to continue. The court may, while taking into consideration the special facts of the case, can also quash the proceedings. Supreme Court, in the third reference of the case, that is G.V. Rao vs. L.H. Prasad, held that the observations made by this Supreme Court, though in a slightly different context, are very apt for determining the approach required to be kept in view in matrimonial disputes by the courts. It was said that there has been an outburst of matrimonial disputes in recent times. Marriage is a sacred ceremony, the main purpose of which is to enable the young couple to settle down in life and live peacefully. But little matrimonial skirmishes suddenly erupt, which often assume serious propositions, resulting in commission of heinous crimes in which elders of the families are also involved, with the result that those who could have counseled and brought about approachment are rendered helpless on their being arraigned as accused in the criminal case. There are many reasons which need not be mentioned here for not encouraging matrimonial litigation, so the parties may ponder over their defaults and terminate their disputes amicably by mutual agreement, instead of fighting it out in a court of law where it takes years and years to conclude, and in that process the parties lost their young days in chasing their cases in different courts. So in the end, Supreme Court held that there is no doubt that the object of introducing Chapter 10A containing Section 498 in the Indian Penal Code was to prevent the torture to a woman by her husband or by relatives of her husband. Section 498 was added with a view to punishing a husband and his relatives who harass or torture the wife to coerce her or her relatives to satisfy unlawful demands of dowry. The hyper-technical view would be counterproductive and would act against the interests of women and against the object for which the provision was added. So there is every likelihood that non-exercise of inherent power to quash the proceedings to meet the ends of justice would prevent women from settling earlier. So that is not the object of Chapter 20A of the Indian Penal Code. In the view of the above discussion, Supreme Court hold that the High Court, in exercise of its inherent powers, can quash criminal proceedings or FIR or complaint, and Section 320 of the Code does not limit or affect the powers under Section 482 of the Code, that is CRPC. For the foregoing reasons, Supreme Court has set aside the impugned judgment and allow the appeal and quash the FIR above mentioned. So in the end, I just want to thank you all for listening me. Please like, subscribe and share my channel. Like and subscribe my channel for more interesting and more knowledge. And thank you so much.